from the police department, if that's all right.
Sure. All right, regarding the police department, one of the primary avenues that we use in enforcement of animal cruelty cases is actually the cruelty to animals statute. In Massachusetts, that's chapter 272, section 77. I won't read all the language, but basically, is if someone is cruel to an animal, it gives the police department the option to file criminal charges against the person. A couple of things I kind of would like to go over. Just law can be very complicated, and I'll try to make this as simple as I can. That particular crime has recently been changed to a felony. So what does a felony mean? In law in Massachusetts, there are misdemeanors and felonies. If a crime is a felony, it's generally punishable by more than 2.5 years in a state prison. So the legislature obviously views that as that's a serious crime, and it's a crime that has more of a bite than a misdemeanor. So when a crime is a felony, it gives the police department more, I don't want to say authority, but more things we can do. And one of the big ones is an arrest. A police officer can make an arrest based on probable cause that occurred in the past. So that means if it's more probable than not that someone committed the crime in the past, the police department has authority to make the arrest, and then it would obviously go to court. Probable cause is what police departments work off of, but honestly, especially as a detective, I want guilty beyond a reasonable doubt. So probable cause is the standard that we are required to meet, but we work very hard at going well beyond that standard so that we give the information or the evidence to whether it's the district attorney or the attorney general's office to prosecute the case with ample evidence and supports what we want, which is a guilty beyond a reasonable doubt. So what do the police do? So if we have a call of animal, and if I talk too long,
Please, this is good one.
if an animal case comes to our attention, if it's an egregious act, right? They always used to tell us in the police academy, egregious, and I don't know how many times I looked that word up because of like, egregious. But egregious kind of means shocking, appalling, terrible, horrendous, frightful, abominable, or abhorrent. So basically it's like as soon as you see it, you know it's wrong. You know it's wrong. It's not something minor. It's, you know, some of the scenarios would be, and not to be mean here, but, you know, tying a dog to a post and then lighting it on fire. That would be a case of animal cruelty that I would have no problem acting on immediately. If I was driving down a main road and someone kicked their little puppy like a football because they were angry, we would have no problem acting on that immediately. Unfortunately, most animal abuse cases aren't quite that simple. They're not that really that black and white. So what do? We try to conduct investigations where we use documentation, like photographs. Photographs are huge. Pictures worth 1,000 words. And in addition to that, we get testimony and evaluations. And what is very helpful for the police department is if we have a paper trail of some type of intervention or education with people. So, you know, someone has an incident, we think that the animals are not taken care of properly. If we can show that there was some other intervention to try to help that, and those measures were not accepted or utilized, that helps us in showing a person's intention. That person's intention is not to care for those animals in the best way. They're going to do what they want to do. And that helps us. I can tell you, I recall a case that we had where there was a dog who looked terrible. It was emaciated, it looked terrible. And we went to the house and conducted an investigation because we don't want to like assume something, right? We want to kind of get our facts in order. And the dog had cancer. It was dying. The family loved it to death. It's just, it was a condition of its illness. But if you were just driving by and you saw the dog in the front yard, it would be reasonable to assume that it was neglected, and that wasn't the case at all. So we need to conduct investigations that are thorough and they're based on facts, not what we think, because sometimes the facts can be very different. Non-compliance is huge for us to show intent, right? If we tell you to do something that's best for the animal and you just don't do it, and we can document that we asked you to do it, that helps us in the criminal end, because obviously the person has a guilty mind. they've chosen not to do what's best for the animal. So non-compliance helps us. And then what we ultimately do is we review the case, and they usually come on my desk, and it pertains to what we call the totality of the case. We look at everything. We look at, was there education, was there this, was there that, is it egregious, is it... Once we make a decision on that, we would then summons a person in or make an arrest. Again, it would depend on the circumstances of the case. That judgment call is made by the police officer. What does that mean? A summons is where someone is brought into the court system to answer for a complaint. Okay? They're not taken into physical custody of an arrest, but they are brought in through a summons process where they have to report to court, and they are arraigned, or the charges are publicly announced in the court of law. That person would get up, they would be arraigned. How do you plead? Most of the time at arraignment they plead not guilty. Once that's entered into the court, then the case continues from that point on. But that's a formal charging of the person. When an arrest occurs, especially in these felony charges, the difference is when we make the arrest, a clerk magistrate, which is a person who works for the courthouse, reviews our probable cause to make sure that we have that level of probable cause to take someone into custody. And once they agree with us, they set up an arraignment, and that person is held or released based on the clerk's opinion. So those are the two avenues. The summons is, it's a paper issue. You're given a date, you have to come into court and answer for the charges. The other one is the arrest. The arrest is the police have formed the opinion that this case needs to be quickly sent before the courts, and that's what happens. Sometimes people will say, well, why didn't you make the arrest? Sometimes that's because we want to get as much evidence as we can. We don't want to rush a case. We want to take our time, put this case together, all documentation, photos, all kinds of reports, and make sure everything is put together completely so that that can go ahead. Two other quick points here that people sometimes get confused. Some cases are brought to the district attorney's office. Some cases are brought to the attorney general's office. Well, what's the difference? The district attorney can bring cases both in district court, which means the punishment can't be more than 2.5 years. And that's where a lot of cases I've heard at that district level. You'll see cases come in district attorneys on uncommon to have 15 cases on one day. So those cases are kind of the meat and potatoes of the district attorney's office. And then it's superior court, which means we can't just send someone to superior court. We have to present the evidence to a grand jury. And that's a bunch of people who sit in a room and they listen to the facts of the case as presented by whether it's the district attorney or the attorney general. And it's generally testimony of the police officer or vet services or photos. And this has to be presented on a case-by-case basis. The grand jury listens to evidence, and then they form an opinion at the end of that of whether or not there's probable cause, more probable than not, that that case needs to go forward. If they do issue it, we call it a bill, and then that person will be tried at superior court level. Okay? So district court level, you go before a judge, it's immediately sent through the system. Superior court level, it has to go to a grand jury. The grand jury. It's not a judicial review by one person, it's a judicial review by a body of people. Some of these people sit on these grand juries for months. You should see the questions they ask us. They're very into what's going on. So that's kind of a quick synopsis of the different types of angles that we can go with criminal cases. They're very complex. Obviously defendants are entitled to certain rights and protections, and that's what our justice system is about, and I agree 100% with those. But it's not always a quick resolution. Sometimes it is, where there's an arrest made, they go to court, and the case is kind of expedited. But there are other cases that go before grand jury, and I've had quite a few cases where I was very happy to wait until they went through the grand jury so that we could put a very solid case together. Where in district court, sometimes the case has to move quickly and we kind of run out of time. Next thing you know, you have a pre-trial, you have to submit documentation and all that. So hopefully I somewhat explain that.
Can I just ask a clarifying question?
Sure.
So I think what I heard you say is if there's an arrest, so something egregious has happened and there's an arrest, that the defendant, is the defendant, he hasn't tried, okay, so they've arrested the defendant, that defendant has some expectation of reasonably swiftly getting some adjudication, but they can get out of bond or bail or whatever. So is that what limits your ability to do the investigation?
I wouldn't say it limits the investigation, it's just you've put in place that this case has resolved, or most of it has resolved. In other words, you have the information you need to form the opinion as a police officer that this person has committed the crime, and the crime was of a nature that required us to take someone's civil liberties from them and place them in custody. So because of that, yes, they get a chance to go to court much quicker. Because now there's reviews, there's judicial reviews, the clerk magistrate reviews, a judge will review it. Because in our system, it's, the police are the executive branch, the judicial system is the different branch. So there's checks and balances in it.
So I have one more question, and then you guys can ask questions. So the other question I had was that I've learned from recent cases that animals are evidence. So can you talk about when and how animals get seized, or when you call in the whole relationship with the Animal Rescue League?
Sure. In fact, one of the big parts of an animal cruelty case is obviously, because you have to look back at why are the police acting on a certain matter, okay? So if the animal's being abused, our number one priority isn't a prosecution, it's ultimately is protecting that animal. So that's when seizures come into play. Our number one responsibility at a crime scene like that is to protect those animals, to prevent them from being harmed any further. That's number one. Number two is obtaining evidence for a prosecution at a later time. But the animals being abused, we have a duty to fix that and to get them as much care as we can. Sometimes it's a matter of getting them surrendered and a vet checks them out, or there are some cases, and I don't want to get into specifics, but where we have to call a big organization to come in and help us. But our number one priority is always the treatment of those animals.
Tim, did you have a question?
Yeah, can you explain, can you explain when the police can get involved and when they can't? What would be examples of situations that may rise to the level of a complaint, and when they don't rise to a level of a complaint?
Absolutely. The police department is...
And that's important for our discussion.
No, absolutely. The police department enforces laws, but we also have a bunch of constitutional protections in place that limit the police. What do I mean by that? I can't just walk into someone's private property, walk in their backyard, because I want to see how their chickens look. A police officer doesn't have that right to do that. That's private property. I need reasonable suspicion or probable cause that a crime is being committed. And that's the problem sometimes with complaints that may be anonymous. So if someone calls in and says, we'll use the bad chicken scenario there, but in the backyard, this is a bad case, they think there's animal abuse. We're restricted. We cannot go on that property. We cannot go on that property. Now, can we knock on the door and ask? Sure. Sure. But if the person tells us no, they have a right to protect their own property, and the police cannot intrude on them to do that. Now, if I have evidence, okay, whether it's facts, testimonial, or photos that can substantiate that there's an animal being abused on that property, we would have to petition the courts for a search warrant, which again, we're back into the court arena. They would have to issue that there was probable cause that there's an animal being abused, and then we would have to act on that. Now, if we have emergency circumstances where I'm outside and I can hear someone, an animal screaming in pain, obviously that's an exigent circumstance and the police would act on that. We're not going to wait to get a search warrant. But especially in these animal abuse cases, a lot of times, it's a field somewhere in the middle of wherever, and that person's property ends here. So we can't just go onto their property and look around, especially being law enforcement. That person has constitutional protections of their property. So we need either evidence to support a search warrant, which allows us to go on someone's property against their will, or we sit back and we just try to collect as much evidence as we can to get us to the level of probable cause to go onto that property. We cannot just go on someone's property. The law enforcement cannot just go on someone's property to check something.